Hi, this is Jim Semsel of Century 21 Abrams and Associates. I'm doing my presentation, which I call Buyer's Insight in Navigating the Post-Settlement Landscape. The purpose of this presentation is to inform buyers about the NAR settlement and how it affects them. Um, so the first slide I have up is called Top 5 Reasons to Hire an Agent When Buying a Home. A lot of people think that buyers agents do mostly just door opening for people, and that's what we do. We don't actually do any. I mean, we have licenses. We do 175 hours of class time and have to take a whole series of tests and stuff. So I would assume, just knowing that we do more than just open doors. We have experience. I have 20 something years of experience. We provide expert knowledge. We explain pricing and market value data. We keep I personally keep my thumb on the pulse of the market, so I know what's going on. We review contracts and the fine print in them and explain them to our buyers so people know what's they're getting into. And we bring negotiation expertise. If you have experience, that's what you have is negotiation expertise. So we're getting to the first slide about the NAR settlement. I wanted to address the prevalent misinformation surrounding the NAR settlement. It's important to clarify two key points that have sparked confusion and debate within the industry. The first misconception is that sellers will no longer cover buyer agent commissions. And the second is the expectation that buyers will be responsible for paying their buyer agent. By dispelling these misunderstandings, I aim to provide clarity and accurate information on this topic. Buyers will likely request the seller to cover buyer agent fee from the sale proceeds. It's crucial to recognize one, a significant portion of buyers come through cooperating agents. The last statistic I heard was 87%. You just think, almost 9 out of 10 transactions involve a buyer's agent. Two, buyers are often financially stretched with down payments and closing costs. Where are they going to come up with the money to pay a buyer agent? So I guess nobody's going to be buying houses anymore if that's the way we're going to be thinking. Three, compensation offers can influence a buyer's property choice. By not offering a buyer's agent compensation, buyers might walk away from your property. Even for sale by owners are very well aware of this and will often offer buyer agent fees to cover buyer agent fees. Um, Refusal to pay the commission might prompt buyers to look elsewhere. So if you're not offering the compensation, they might not even think about purchasing your home. So just consider this. Could you afford your buyer agent commission up front? Most buyers will still ask sellers to cover it. All right, first one, change number one. The MLSs are now prohibited from publishing buyer agent compensation, underscoring the need to clearly establish compensation arrangements with your agent. Number two, in the past, buyer agents would show homes without any agreement in place. This was done for free with the hopes that the prospect would make an offer through the agent and therefore the agent could earn a paycheck. Oftentimes, that prospect would not buy that home, much to the disappointment of the showing agent. This enhanced the idea that buyer's agents simply open doors to prospects and clients, since often agents would rush to show properties without having a basic idea of who they were meeting. Isn't that kind of scary? Okay. We're going to get into an aspect of real estate relationships, something everybody needs to know. But I'm going to go back to the previous slide real quick. And I'm just going to give you my thoughts on these two things. These are the two big things that affect buyers today. And I think this is a huge positive for buyers because it gives them the opportunity to negotiate the buyer agent fees, the person that they're working with. It also gives them the opportunity to say, hey, you know, this is the person I want to work with. So you can feel that you're working with a qualified agent. You're not just going to an open house and whoever the agent is on duty is the person that you're going to be paying to represent you in a transaction. I don't think that really works very well for some people, and it gives a really bad impression on the industry that way. But that's the way it's been working for a while. So, next. Okay. Here we are, understanding agency relationships in real estate. We're diving into the essential aspect of the real estate industry, agency relationships. Understanding these relationships is crucial for both clients and professionals in the field. We'll explore the dynamics between clients, agents, and brokers, shedding light on the roles, responsibilities, and obligations involved. By the end of this presentation, you'll have a clearer understanding of how these relationships shape transactions and interactions within the real estate market. Let's get started. In this slide, we discuss the crucial role of brokers in the real estate industry. Brokers serve as the legal and regulatory foundation for agents, ensuring compliance with laws and ethical standards. Their oversight is vital for maintaining professionalism and upholding fiduciary duties to clients. This symbiotic relationship between brokers and agents fosters a culture of accountability and consumer protection, ultimately benefiting all stakeholders in the real estate market. Today, we're delving into the concept of agency relationships in real estate. Simply put, an agency relationship occurs when one party, known as the agent, acts on behalf of another party, the client, with the client's authorization and under their control. It's important to understand the roles involved in this dynamic. The client is the individual or entity seeking the service of the agent, while the agent is the representative authorized to act on behalf of the client. Additionally, we have the broker who plays a crucial role in supervising agents and ensuring legal compliance with the agency relationship. Understanding these roles is fundamental to navigating the complexities of real estate transactions and relationships. In the realm of real estate, various types of agency relationships govern transactions. Let's explore these different types. One, a seller agent, also known as a listing agent, represents just the seller in a transaction. They work to secure the best possible deal for the seller. Buyer's agents represents the buyer in a transaction. They work to secure the best possible deal for the buyer, and they advocate for their best interests throughout the transaction process. Dual agency, number three, dual agency occurs when a single agent or brokerage represents both the buyer and seller in the same transaction. It's important to note that dual agency comes with inherent conflicts of interests and requires special disclosure. Designated agency involves assigning different agents within the same brokerage to represent the buyer and seller in a transaction, thereby mitigating potential conflicts of interest. Understanding these various types of agency relationships is essential for both clients and agents to ensure transparency and effective representation in real estate transactions. In the real estate industry, Agents owe fiduciary duties to their clients, which are essential for maintaining trust and integrity in transactions. Let's break down these duties. 1. Loyalty. Agents must always act in the best interest of their clients, prioritizing their needs above all else. 2. Obedience. It's crucial for agents to follow the lawful instructions provided by their clients throughout the transaction process. C. Disclosure. Agents are obligated to provide all relevant information to their clients, ensuring transparency and informed decision making. E. Confidentiality. Maintaining client confidentiality is paramount, and agents must safeguard sensitive information from unauthorized disclosure. F. Accounting. Agents are responsible for handling client funds and property with the utmost care and integrity, maintaining accurate records and transparency. G. Reasonable care and skill. Agents are expected to exercise due diligence and expertise in representing their clients, ensuring competent and professional services at all times. These duties form the foundation of the agent client relationship, fostering trust and accountability throughout the real estate transaction. Brokers play a pivotal role in the real estate industry, shouldering significant responsibilities to ensure smooth and lawful transactions. Let's delve into their key responsibilities. 1. Supervision of agents. Brokers are tasked with overseeing the activities of their agents, ensuring they operate within the bounds of the law and adhere to industry regulations. 2. Compliance. It's crucial for brokers to ensure that all transactions conducted by their agents adhere to ethical and legal standards. This includes proper documentation, adhering to fair housing laws, and transparent communication with clients. By fulfilling these responsibilities, brokers uphold the integrity of the real estate profession and promote trust and confidence amongst clients and stakeholders. So if you have an issue with your agent, talk to the broker. When it comes to establishing agency relationships in real estate, there are two primary methods to consider. One, written arrangements. Formal contracts such as listing agreements for sellers and buyer representation agreements are common ways to establish agency relationships. These agreements outline the terms, responsibilities, and obligations of both parties involved in the transaction, providing clarity and legal protection. 2. Implied agency. In some cases, agency relationships may be established implicitly through the actions and conduct of the parties involved. This means that even in the absence of a written agreement, the actions of the agent and the expectations of the client may create an agency relationship. It's important for both agents and clients to be aware of these implications and to communicate clearly to avoid misunderstandings. These methods of establishing agency relationships ensure transparency and clarity in real estate transactions, benefiting both parties involved. It's essential to recognize that written agreements take precedence over implied agreements. The concept of dual agency and its implications in real estate transactions. Let's break down what this means. Definition. Dual agency occurs when a single brokerage represents both the buyer and seller in a transaction. This can happen when an agent from the same brokerage represents both parties, or when two agents from the same brokerage represent the buyer and seller separately. Two, conflicts of interest. Dual agency can lead to potential conflicts of interests due to the dual agent's loyalty to both the buyer and seller. In such situations, the agent must navigate carefully to ensure fairness and transparency in the transaction. Disclosure requirements. Dual agents are required to disclose their role to both parties involved and obtain informed consent from each party. This ensures that both the buyer and seller are aware of the dual agency agreement and understand its implications. By adhering to disclosure requirements, dual agents promote transparency and trust in real estate transactions, mitigating potential conflicts and misunderstandings. Designated agency in real estate transactions and its significance. Here's what you need to know. Definition. Designated agency enables different agents within the same brokerage, just like dual agency, within the same brokerage to represent the buyer and seller in a transaction. Unlike dual agency, where one agent represents both parties, designated agency assigns separate agents to exclusively represent each party involved in the transaction. Distinction from dual agency. The key difference between designated agency is in the exclusivity of representation. Designated agents focus solely on representing their assigned party, thereby avoiding conflicts of interest that may arise in dual agent scenarios. Benefits. Designated agency offers several benefits, including specialized representation for both the buyer and seller, having dedicated agents advocating for their respective clients' interests. Designated agency can enhance transparency, promote trust, and mitigate potential conflicts throughout the transaction process. This model ensures that each party receives tailored guidance and advocacy, contributing to a smoother and more satisfactory real estate experience for all involved. Managing conflicts of interest. In the real estate industry, conflicts of interest can arise, but there are strategies for effectively managing them. One is transparency and disclosure. It's crucial to maintain open communication with all parties involved and disclose any potential conflicts of interest upfront by being transparent about these conflicts and discussing how they will be addressed. You can build trust and ensure everyone is on the same page. Prioritizing clients' interests. Regardless of the situation, always prioritize the best interest of my clients above all else. My fiduciary duty requires me to act in your best interest and advocate for you throughout the transaction process. Seeking guidance. When faced with complex conflicts of interest, I don't hesitate to seek the guidance of my broker or legal counsel. They can provide valuable insight and advice on navigating the situation while upholding ethical and legal standards. Effectively managing conflicts of interests requires proactive communication, ethical decision making, and a commitment to prioritizing client interests at all times. The Next, we're going to get into the buyer agency agreement, which plays a pivotal role in formalizing the relationship between buyers and their agents. But I want to go back to agency relationships. I really want to say something very important. If you go to an open house and you're going to make your offer through the agent on duty because that agent on duty is the listing agent. Please be aware that that agent on duty represents the seller because they have a written agreement with that seller to represent that seller, and they represent that seller until they sign an agreement with you, Mr. Buyer. Until that moment that they sign that agreement with you, they are representing you in good faith and in fairness, but their main objective is to represent the seller and the seller's best interest. So, not taking anything away from any of the agents, not saying they're doing anything wrong. I'm just saying that that is where their loyalty is. And they still, all agents have to act in the best interest of the general public when we meet them, and I'm certain that all of these listing agents are 100% ethical and will treat you fairly and properly, but they have no written obligation to do so, just so you are aware. Okay, exclusive buyer agency agreement. We're going to explain the concept and the importance of exclusive buyer agency agreements in the real estate transaction. This is something that I have used in the past. And the form that we're using now, as we're being asked to, is different than it was when I first started using them about 15 years ago. 15 years ago, all we basically said was, hey, you're my agent. Yes, I am. And we talked about agency relationships in the document, and we document, and it's in this document too. We're going to document dual agency or strictly buyer agency. So let's get into that. So the concept of exclusive buyer agency agreement and its significance in the real estate transaction. Here's what you need to know. Definition. An exclusive buyer agency agreement is a contractual arrangement between a buyer and a real estate brokerage firm. In this agreement, the brokerage represents only the buyer's interests throughout the transaction, providing dedicated advocacy and support. Key points: buyer representation. One of the primary features of an exclusive buyer agency agreement is that the agent works exclusively for the buyer. This means that the agent is committed to advocating for the buyer's best interest at every stage of the transaction, from property search to closing. This is a legal contract. An exclusive buyer agency agreement is a legally binding contract that outlines the terms and conditions of the agreement between the buyer and the brokerage. It typically includes details such as the duration of the agreement, the scope of services provided by the agent, and the compensation structure. By formalizing the relationship between the buyer and the brokerage, this agreement helps ensure clarity, transparency, and accountability throughout the transaction process. Just so everybody keeps in mind, from a buyer's perspective, when somebody puts their house on the market through a realtor, the realtor will sign a listing agreement, and that listing agreement that makes them the listing agent. So that listing agreement is basically the same as what the buyer agency agreement is, with the exception of, well, on one part we're going to help sell your house, and the buyer agency is, we're going to help you buy a house. So that's the key difference. A lot of the verbiage and a lot of the other things in the agreement are almost identical. So Part one, this is an actual copy of the agreement. If you want to, I can email you a copy of this agreement. This is the agreement that I'm going to be using from now on. Part one, this section of the agreement establishes the agency relationship between the buyer and the brokerage firm. Here's a breakdown of the key points. Buyer designates the brokerage firm as their exclusive agency, referred to as the buyer's agent, for the purpose of purchasing real estate within specified areas. The individual agent who signs the agreement on behalf of the brokerage firm is primarily responsible for ensuring that the firm's duties under the agreement are fulfilled. Other agents of the firm may also be assigned duties as deemed appropriate. It's important to note that the brokerage firm and its agents are obligated to conduct all activities related to the agreement without discrimination based on various protected characteristics such as race, religion, sex, disability, etc. The most They must comply with all state, federal, and local fair housing and anti-discrimination laws throughout the transaction process. Part two, this is still the form. This is what the rest of the presentation is going to be, this form. I'm going to do each part of the form. This section addresses the buyer's existing business relationships with other brokers and their obligations to the buyer's agent under this agreement. The buyer confirms to their agent whether they have any existing buyer agency agreements for the specified area and agrees not to enter into such agreements during the term of this agreement. I'm going to just jump back to the previous page. We're on part one here. We're going to look at line 6 real quick. I just want to point out, oh, crap. Line 6. It says here, line 6, real estate by buyer in the following areas. And in that area, in that part of the form, you will say, okay, the state of New Jersey. This is the agent I'm hiring to help me in the state of New Jersey. Or this is the agent I am hiring to help me find a home in some particular city. It can also be a specific address. And I'm pointing this out because if you're going to an open house and the realtor on duty is throwing this form in front of your face saying you have to sign it, which is what's going to happen come when the settlement is in place, I'm going to ask you, the buyer, to check that line and make sure that they have put just that address on the form. If they have not, write it in yourself and make sure, if they're forcing you to sign it, make sure you get a copy that is an exact copy of what you signed, so you are fully aware of what everything is. Okay. So I want people to be very aware that they're not going to go to an open house and have this form shoved in front of them and then go to the next open house and have the form shoved in front of them again. And then when the time comes and they decide that they want to buy a house, they now have to pay commission to all the agents that they saw that day because they decided to buy one house that they saw on that day. That is not going to happen, especially if you pay attention to line 6. Okay, so I really want people to be aware of that. So I'm going to get over here to part 2. And this section addresses the buyer also confirms that they have disclosed information about any properties they've visited or been shown by other real estate brokerage firms within the specified area before entering into this agreement. Once again, I'm going to go back to the whole open house idea. If you did go to an open house and the form was shoved in front of your face and you did sign it, but you didn't check line 6, make sure you tell the agent that, yeah, I was in an open house half an hour ago down the block here, and they made me sign this stupid form. And I don't, at least that agent will be aware. So now they can kind of say, okay, they might be going into, they might be getting an issue if they decide to make an offer on this house. Okay. By employing the buyer's agent as their exclusive representative, The buyer agrees to conduct all negotiations for properties in the specified area through their agent. They also commit to referring all inquiries received from other real estate brokerage firms or prospective sellers to their agent during the term of this agreement. Additionally, the buyer acknowledges that the brokerage fee, as outlined in the agreement, is due and payable even if they acquire real property on their own or without the assistance of their agent. This clause reinforces the exclusivity of the buyer's agent and their entitlement to compensation for their services, regardless of the outcome of the transaction. I'm going to mention the idea of working in good faith. If you do sign an exclusive agency agreement with an agent who you want to work with, make them aware if you have signed any of these other agency agreements going through open houses, and you should have a copy of those. Present your copy to them so they can see it, so they can let you know. There's no such thing as a contract of this nature that doesn't have an escape clause of some kind. We'll get into that in a few minutes, the escape clause. And they should be able to help you with how to work out for going forward at this point. This is also an important section because let's say you're moving from the West Coast, California, to New Jersey, and you have a house for sale in California. Well, your buyer agent is going to want to be aware that you are selling a house in California, and they may want to contact the agent you have in California so that we know what's going on. How's the house sale going? Oh, we haven't had any offers yet. That's going to delay the home buying process because you need to sell one to buy the other. Um, what's the holdup? So what's going on? How's the market over there? You know, I as a buyer agent would want to know and feel that my client, my buyer, is being properly represented at the other end of the transaction, that they need to get closed so they can get moved into the next property. So, and I also want to know, like, oh, they are under contract, they're closing next week, which kind of means that my buyer might be in a situation where they need to close immediately. And, as long as I'm aware of it, I can put a little fire under everything so we can get things moving. It's important to know. It's a great way to do. It's important to know. It's how you do business, so everybody knows they're on the same page. Okay, next slide. Part 3. In this section, the declaration of the business relationship between the real estate licensee and the buyer is addressed as required by the real estate license law of New Jersey. The authorized representative of the licensee declares their intention to work with the buyer and specifies the basis of the business relationship with the buyer's firm. The representative must choose one of the following options. 1, buyer's agency only. The representative intends to exclusively represent the buyer's interests throughout the transaction. Buyer's agent and disclosed dual agent if the opportunity arises. The representative intends to represent the buyer's interests, but may also act as a disclosed dual agent if the opportunity arises. The potential for the buyer's agent to work as a disclosed dual agent will occur if and when the buyer expresses interest in inspecting or viewing a property listed with the brokerage firm. This clause outlines the circumstances under which the buyer agent may assume a dual agency role and underscores the importance of disclosure and transparency in such situations. In essence, if you're the buyer, you're going around, you're looking at, we're going to say we look at a dozen homes. One or two of those homes that we looked at during the course of our tour for the day may have been listings that were within my brokerage firm. If they are, and you need to be aware of it before we see them, that if you decide to move forward with it, I become a dual agent. You need to be comfortable with me being a dual agent so that I can show you all the houses that are on the market and available to you. If you're not comfortable with me being a dual agent, it's something we need to discuss if we sign this agreement. We need to document how we want that dual agency to be covered. Um, Oftentimes, what I can do is I can refer you to another agent. I have great working relationships with other agents in other offices. I can refer you to them, and they will take over for everything and get you to close. I know, and they're really good. So I've worked with them a number of times, and that's what I would do if you're really not comfortable with me being a dual agent. So, but that is something that is specified from the beginning, that how we're going to do that. Okay. This is also something that you find in listing agreements, and a seller will often check disclose dual agent, and the listing agent will ask for that. Please, let's do disclose dual agent, so that way if a buyer comes in and calls me directly, I can work with them. And I mean, obviously, they want to do that. They've made some effort into putting this house on the market. They are certainly entitled to have the opportunity to work with buyers who are just coming off the streets looking for a home, and maybe they just found the perfect one. It does happen. So that gives them the opportunity to do that. This gives me the opportunity. Oops, didn't mean to. I'm back in part one. I hit a button by accident. Anyway, gives me the opportunity to make sure I can show you all the houses on the market, especially when I hear, "Hey, we just got a new listing, and its first showings are on Friday." And I hear about it and go, "Oh, that would be great for my buyer." I call you up. I can feel comfortable calling you up and saying, "Hey, we just got a new listing. I want you guys to see it on Friday when the first showings happen." So and when I call you up and say, "This is going to be dual agency, but let's go and let's take a look at it," and we're already squared away. So this is done for your comfort. We want to be working in good faith at all times. Part 4. This is important. This is your escape clause. Here you'll specify the duration of the agreement and note the provision for cancellation. The agreement's terms begin on a specified date and ends when the buyer acquires property as outlined in section 1, or at midnight on the specified day, or within 3 days if no dates are filled in. Within 3 days after receipt of a written termination notice from the buyer's agent or the buyer, whichever comes first. This term is subject to the protection period outlined in section 5A. Once again, I'm just going to say working in good faith. If you are working in good faith with your agent, and let's be honest, we're all people, we're all human beings. Sometimes we just don't get along. And if you don't get along with me, I understand that. I'm not happy about it. I want to get along with everybody. But if you don't get along with me, I understand. Write me a note saying, "Hey, Jim, I want to terminate the buyer agreement that I have with you because I don't feel like we're going to be able to purchase a home through you." I understand that. We'll cancel the agreement and you can move on. It's important to note that the term of the agreement cannot be extended without the buyer's written consent. This clause ensures that the duration of the agreement is clear and that both parties understands their rights and obligations. Additionally, there's an escape clause that allows either party to cancel the agreement within 3 days of its execution with written notice. This provision provides a safeguard for the buyer and ensures that they have the opportunity to review and potentially cancel the agreement if necessary. Please keep in mind, we're working in good faith. I, as your buyer agent, am working in good faith for you. You, as the buyer client, are working in good faith with me. Nobody's trying to trick anybody here into or force anybody into buying a home or buying a specific home. We're trying to work together to find the right place. Part 5.1. Now, part 5 of this agreement is long, so I've had to break it down into a few separate parts. So we're going to go with part 5.1. Buyer specific information regarding compensation to the buyer's agent is detailed here. The buyer agrees to compensate the buyer's agent with a commission which can be negotiated individually and agreed upon between the buyer and buyer's agent. This compensation can be structured as a flat fee or a percentage of the total purchase price. It can be negotiated in another format as mutually agreed upon. It's important to note that the amount, format, or rate of the brokerage fee to be paid to the buyer's agent is not fixed by any law, governmental agency, trade association, or multiple listing service. This allows for flexibility in negotiating the compensation arrangement based on the services provided. The buyer may also be required to pay a retainer fee, which is non refundable and due at the time of signing the agreement. The retainer fee will be credited towards any compensation owed to the buyer's agent unless otherwise agreed upon in writing by both parties. Also, note that discussions of compensation are not a matter or an individual matter between you and your agent, and they will not be discussed here. So I'm going to put out there, if I talk about commission structures and I use a percentage, it's just because I wasn't using my brain when I was talking. We're going to, when I say a commission number, just think X. Commissions are X. They're whatever you and I negotiated. Okay. Part 5.2. This section outlines the circumstances under which the brokerage fee is earned and due to the buyer's agent, as well as the agent protection clause. The brokerage fee becomes earned and payable under various circumstances, including if the buyer enters into an agreement to purchase any real estate seen during the term of the agreement, or if they enter into a contract within the protection period after the agreement expires. If the seller has agreed to pay the buyer agent, those funds shall be credited to pay the buyer's agent as outlined in the agreement. The brokerage fee becomes due and payable at the distribution of proceeds from the sale of the real estate at closing or upon the buyer's default of any contract to acquire the real estate. It is important to note that if the buyer defaults, the total compensation due to the buyer's agent will be payable immediately by the buyer. The buyer's agent also reserves the right to pursue compensation from the seller or seller's agent if the seller defaults under the terms of the sales contract. Additionally, the agreement specifies that the compensation for the buyer's agent includes all amounts allocated to furnishings, fixtures, and other concessions or credits agreed upon by the buyer and seller as part of the purchase price. This ensures that the buyer's agent is compensated fairly based on the total value of the transaction. What this basically is saying is if you the buyer, and this goes for the seller too, get into a contract to sell the house, and all of a sudden you decide you're not going to sell the house or buy the house, whoever is in default on that contract will still have to pay the agent fees. This is also something that's outlined in a listing agreement. If a seller is selling their house and because they're moving to Oshkosh, and all of a sudden, because they get a new job in Oshkosh, and all of a sudden, a week before closing, they get a call from their boss that they're not moving to Oshkosh and that whole deal is off now and they need to stay in New Jersey. Well, now that seller has to talk to their boss and say, well, I sold my house and I'm now in default on the sale of the house. I need to compensate the agents involved in this. So that becomes a whole settlement issue, and the attorneys will take over from there. Um, if we're all working in good faith, we should never have any problems. Honestly, if a situation like I just mentioned does happen, we're all working in good faith. Yeah, I apologize to the buyer. I'm sorry you're not going to be getting the house that you thought you were going to be getting. Um, I'm sorry that that would happen. I would hate to see that happen, but it does happen. It has happened. So anyway, on to the next slide. Part 5.3. This section addresses compensation from the seller to the buyer's agent and outlines the procedures for crediting the brokerage fee. Please note lines 108 and 110. We said earlier in this presentation that some people are under the assumption that sellers will no longer be asked to compensate buyer's agent. Well, this agreement right here specifies that you are asking your buyer agent to put into the clause and into any contracts they write that you are asking the seller to pay the buyer's agent for the buyer's agent services in any offer written by the buyer agent. So this way, the buyer agent gets paid out of the proceeds of the sale. Okay. If the seller authorizes the listing broker to pay a portion of the brokerage fee to the buyer's agent, that portion of the fee shall be credited against the buyer's obligation to pay the buyer's agent, except in cases where the buyer's agent is a disclosed dual agent. In such cases, the entire brokerage fee must be paid by either the buyer or the seller. Basically, what that is saying is the buyer's attorney, the buyer side is going to make sure that the buyer's agent gets paid. The seller side is going to make sure the seller's agent gets paid. If it's a dual agent, since they're both in the same place, that agency is going to make sure that the agency gets paid. That's just a little bit of legal mumbo jumbo, I would say. Next, if the seller offers compensation to the buyer's agent that exceeds the amount agreed upon between the buyer and the buyer's agent, the buyer is entitled to a credit for the excess amount unless otherwise agreed in writing. What that basically means is if the seller is offering Y as their compensation to the buyer's agent, and the buyer's agent is offered X from the buyer, the difference between X and Y gets credited back to the buyer if Y is greater than X. If X is greater than Y, now we're going to have a discussion with your buyer agent about how we're going to move forward. I don't know very many buyer agents who are going to be not working in good faith at that point and not accept what the seller is offering. That doesn't mean that, I will never work for nothing. So I don't think anybody would expect me to. And I think it's fair not to expect somebody to work for nothing. Next, if the seller offers less compensation than agreed upon, the buyer directs the buyer's agent to introduce them to properties regardless of the compensation offered by the seller. The buyer also instructs the buyer's agent to include specific terms, if any, offer to the seller regarding payment of the brokerage fee for the buyer's agent services. These terms ensure that the buyer's agent is compensated appropriately for their services in various scenarios. The bottom line on all this is we're working in good faith, and my good faith to my clients is yes, I will get paid at the end of all this for my services. I think that's a fair way to put it, and I don't know many people who are going to get very upset if they do get a paycheck at the end of it. Maybe I won't get as much as I intended to get or wanted to get, but if I have a happy client at the end of the day, I'm good with that. And if I do have to take it on the chin a little bit for my clients, I do ask you, please write me a good review. Thank you. All right, part 6. This section outlines the duties and responsibilities of the buyer's agent during the term of the agreement. The buyer's agent is obligated to promote the interests of the buyer by diligently searching for a property that meets the buyer's criteria and exercising ordinary care while compliant with all relevant laws and regulations. Excuse me. They must utilize their professional knowledge and skills to assist the buyer in negotiating the purchase of the property and represent the buyer's best interests throughout the transaction. Additionally, the buyer's agent is responsible for helping the buyer understand financial issues, providing information on market conditions, scheduling property showings, and disclosing all material facts related to the property or transactions. Um, they are also tasked with preparing and negotiating written offers on behalf of the buyer, suggesting professional referrals if requested, arranging home inspections, scheduling final walkthroughs, and assisting in resolving any issues that may arise. This section concludes with an opportunity for any additional duties or responsibilities to be included as agreed upon by the buyer and the buyer's agent, ensuring clarity and alignment of expectations throughout the transaction process. Very simply, these are standard buyer agent duties. Century 21 has a buyer service pledge, and they break everything down into 21 specific duties that a buyer agent has. Here we have an extra one, which is on line 131 or M, if you look at it, where there are going to be additional duties, things that uh, your buyer agent should be aware of. You know, we need extra time because my wife is in a wheelchair and we need to be able to tour homes that don't have stairs, things of that nature. Things you need to make sure that your agent is aware of so that everybody's comfortable. And it's very important that you do let your buyer agent know some things that may not be in the standard view of things. What if you have somebody, you want to say, we're not going to look at any homes that were the residence of smokers. I can understand that because you don't want the smell of smoke in the house. You're not going to be buying that. So you can write that in there. Do write that in there if that is an issue for you, especially if you have a serious issue with it, like an allergy or something like that. So, next slide. Part 7. This section outlines the duties of the buyer to the buyer's agent during the term of the agreement. The buyer is responsible for providing accurate and relevant personal information to the buyer's agent regarding their financial ability to purchase real estate. They must inform the buyer's agent of any property they become aware of or are introduced to as a possible property for purchase, even if they find the property themselves. Any offer to purchase or contract on a property shown to the buyer by the buyer's agent must be submitted through the buyer agent. The buyer agrees to work exclusively with the buyer's agent and to refer all information about properties of interest to the buyer's agent. Property examinations should only be conducted by appointments made through and accompanied by the buyer's agent unless otherwise agreed upon. All negotiations and communications related to the property should be conducted through the buyer's agent. The buyer is also responsible for conducting all due diligence on a property in consultation with the buyer's agent and for paying for any products or services required in the examination and evaluation of the property unless otherwise agreed upon in writing by the buyer's agent. These duties ensure that the buyer and buyer's agent maintain a transparent and collaborative relationship throughout the transaction process. I will give you an example of one of the things we're talking about, particularly in the last part when we talk about inspections and consultations. If you hire a home inspector, I'm not paying for the home inspector. You guys are paying the home inspector. And the reason for that is I can't be responsible for what that home inspector might find or not find. I can't be, it's kind of like getting a second opinion from a doctor. You know, do you go to your doctor and say, hey, doc, I realize you need to have 12 stents put into my heart. I want to get a second opinion. What doctor do you recommend? Do you think that doctor is going to, I mean, a doctor is going to tell you a good, somebody else he thinks is a good doctor, of course. Um, but you're really going to that other doctor just to clarify that you need 12 stents and not a dozen, a dozen more, or maybe just one, who knows. You want to make sure you get the right opinion. And I can only recommend people I've worked with before. I am not going to say that you're going to be 100% satisfied with them because I don't know how you're going to get along with them. So it's understood that I can only recommend people that I've worked with before, and I can't be held responsible for your judgment of their doing their job. Part 8. This section addresses the possibility of the buyer's agent representing other buyers for the purchase of the same property. It's acknowledged that other potential buyers may be interested in the same properties as the buyer, and the buyer's agent may represent such other potential buyers regardless of whether it occurs before, during, or after the termination of the agreement. In such situations, the buyer agrees that the buyer's agent will maintain confidentiality by not disclosing the terms of the buyer's offer or any other confidential information concerning the buyer to any other potential buyer. Similarly, the buyer's agent will not disclose the terms of any other buyer's offer or confidential information concerning other buyers to the buyer. This provision ensures that the buyer's agent maintains confidentiality and neutrality when representing multiple buyers for the same properties. If the buyer is uncomfortable with this arrangement, it's crucial to discuss it with the buyer's agent before signing the agreement to ensure clarity and alignment of expectations. As we go through this document, you will see and hear numerous times from me, if you're uncomfortable with this situation, talk about it before we sign it so we can come up with some kind of agreement of what we're going to do in these situations. A lot of this is just speculation of what might happen. Unlikely that they'll happen, but they might. What if? What if a meteor strikes Hawaii? I don't know. That's the kind of thing. What happens if? What if aliens invade the United States? I don't know. What do we do in that situation? So that's the kind of questions that you're going to see. So we have to cover these what ifs and really be prepared. And everybody's working in good faith here. Good faith is a key word. Part 9, authorization of dual agency. This section addresses the authorization of dual agency and its implications for the buyer's agent. The buyer acknowledges that the buyer's agent may choose to represent a seller as well as the buyer in the sale and purchase of the seller's property. In such cases, the buyer's agent will act as a dual agent representing both parties. As required by law, the buyer's agent must obtain written informed consent from both the seller and the buyer to act as a disclosed dual agent. The buyer understands that by consenting to the buyer agent being a disclosed dual agent, there will be limitations on the agent's ability to represent either partly, fully, or exclusively. The buyer's agent must maintain impartiality and cannot prioritize the interest of either party over the other. The buyer consents to the buyer's agent being a disclosed dual agent is deemed to have been given when the buyer signs the attached informed consent to dual agency document. So there's another document you would have to sign as well as this called the informed consent to dual agency to go along with this so that we could go into dual agency. I myself would probably just take the informed dual agency consent form and bring that with me and let you know, hey, I just listed this great property. I think you'll love it. You see it and you love it. Hey, now I'm a dual agent. But you should already know that when I said I just listed this great property and now you're seeing it, now you're buying it. You knew from the get-go that I would go into dual agency. So as part of the documents we would sign as your offer on the property would be an informed dual consent or informed consent to dual agency. This provision ensures transparency and clarity regarding the buyer's agent role and responsibility when acting as a disclosed dual agent, and it emphasizes the importance of obtaining informed consent from both parties in the transaction. See Section 3 of this agreement. So we've already gone through this a number of times. You really need to understand agency agreements as you move forward in purchasing a home. Okay, Part 10, no warranties. This section outlines the absence of warranties or representations made by the buyer's agent regarding the value or suitability of any property to the buyer's purposes. The buyer's agent does not provide any warranties or representations regarding the value or suitability of any property for the buyer's purposes. It's the buyer's responsibility to conduct all necessary inspections, inquiries, and investigations to ensure the property's suitability and value. The buyer agrees to indemnify and hold the buyer's agent harmless from any liability, claims, losses, damages, lawsuits, or expenses incurred as a result of the buyer's selection and use of any services, or the buyer's decision not to have certain services performed. Additionally, the buyer agrees to indemnify and hold harmless the buyer's agent from any claims arising from false or incomplete information provided by the buyer. This indemnification includes reimbursing the buyer's agent for any attorney's fees and costs incurred in relation to any disputes brought against them. This provision emphasizes the importance of the buyer conducting their due diligence and assumes responsibility for their decisions and actions related to the property transaction. It also protects the buyer's agent from potential liabilities arising from the buyer's decisions or actions. I will give you an example of this kind of thing so people understand. You're looking for a property and there is a specific thing you need in it. I had people who were looking for a horse farm. I found them a horse farm. I told them, I said, I don't know anything about barns for horses. You're going to have to come and look because I don't know anything about horse barns themselves. I don't know what you need in a horse barn. I don't know what you would want in a horse barn. I don't know anything. I barely even know how to ride a horse. I know how to get up on a horse and hold on to the reins for dear life. That's all I know about horse. Okay. So it's important that you, the buyer, inspect any property that you're going to buy to be sure that it's going to fulfill the services, the things that you need. I had a client who needed a room that would be a studio. I know a little bit about studios. I found a property that I thought would be a good property. He came in and he saw the photos, came in, looked at the studio, and the one thing I didn't notice, but he noticed because is that it wasn't a soundproof room. So he needed to soundproof the room. So these are things because I didn't know what kind of studio he was looking for. Was he looking for a music studio? Was he looking for a visual studio that he was going to do things like of this nature? What was he looking for? So it's important that you, the buyer, any property you are going to buy, you inspect yourself to be sure it is meeting your needs. Okay, next part. Part 11. This section advises the buyer to consider inspections before making an offer on a property. The buyer's agent recommends that any offer to purchase a property should be contingent upon the buyer's inspections of the property by a licensed inspector and or other professionals. It emphasized that the buyer's agent does not possess expertise in inspection matters, and therefore it's the buyer's responsibility to interview and select all inspectors. This recommendation underscores the importance of thorough inspections to uncover any potential issues with the property before finalizing the purchase. It empowers the buyer to make informed decisions about the property's condition and any necessary repairs or modifications. I personally, I've seen a lot in this market right now. A lot of people are buying homes and they're waiving their right to inspection. This is fine if you want to waive your right to inspection and that gets you a better more purchasing power, fine. But I do recommend to all of my buyers get the home inspected and at least put in there the home will be inspected for informational purposes only. You don't want to buy a home that has a serious defect in it that can only be found by having the home inspected. If you do have a home that has a serious defect in it and you waived your inspection, I'm sure that we can talk with attorneys about, oh, we have radon in the basement. What do we do? Well, radon is a serious issue. So now we have to go on to radon remediation and we can discuss with the attorney, what the options are at that point. So I'm saying I'm going to put that onto the attorney, and I'm saying that because I have dealt with that before, but I'm not going to tell you what the solutions are. We have to see what the attorney says. Part 12, we call love letters. Don't do it. This section advises against sending personal letters to the seller when making an offer on a property. Personal letters from the buyer to the seller expresses reasons for wanting to purchase the seller's real estate, often contain information that could influence the seller's decision to accept or reject an offer. However, this information could potentially be used in a discriminatory manner, knowingly or unknowingly violating state and or federal fair housing laws. To avoid potential legal issues and the appearance of impropriety, the buyer's agent recommends that the buyer refrain from submitting such letters to the seller. If the buyer decides to send a letter to the seller despite this recommendation, they understand and agree that the buyer's agent will not send the letter to the seller. Instead, the buyer will send the letter directly to the seller and will be solely responsible for its contents. The advice aims to protect the buyer and the seller from any legal complications or accusations of discrimination, ensuring a fair and lawful transaction process. Part 13. This section outlines the process of obtaining professional referrals from the buyer's agent. The buyer has the option to request the names of attorneys, inspectors, engineers, title companies, mortgage advisors, trade people, or other professionals from the buyer's agent. It's important to note that any names provided by the buyer agent should not be interpreted as a recommendation or testimony of competency for the referred person. The buyer assumes full responsibility for selecting these professionals and acknowledges that the buyer agent will not be held liable for any claims or actions resulting from the work or duties performed by these professionals. This provision emphasizes the buyer's autonomy in selecting professionals and ensures that the buyer's agent is not held accountable for the performance or outcomes of the services provided by the referred professionals. It encourages the buyer to conduct their due diligence when choosing service providers for their real estate transaction. I know a whole bunch of inspectors. I know title companies. I know mortgage people and various tradespeople. I've worked with them all. I think they're all good, but I can't guarantee that their service is going to be the best for you. It's really up for you, the buyer, to review each one of them on your own and make the decision according to your needs. Part 14, applicable laws. This section specifies the governing laws and venue for any disputes related to the agreement. The agreement shall be governed by and interpreted in accordance with the laws of the state of New Jersey. Any arbitration or lawsuit arising from or relating to the agreement shall be conducted in the state of New Jersey. This provision ensures clarity regarding the legal jurisdiction and venue for resolving any disputes that may arise between the parties involved in the agreement. By specifying the applicable laws and venue, it helps streamline the resolution process and avoids confusion or disputes over jurisdictional issues. This clause provides a clear framework for addressing legal matters, promoting efficiency and fairness in dispute resolution. Next slide. Part 15, arbitration. This section outlines the dispute resolution process and provisions for attorney's fees. Both the buyer and the buyer agent agree that any dispute arising from or related to the agreement shall be submitted to arbitration. Arbitration will be conducted before the American Arbitration Association or a realtor association located in the state of New Jersey, depending on the choice of the party filing for arbitration. If arbitration or a lawsuit is filed by either party concerning any issues arising from or related to the agreement, the prevailing party will be entitled to reimbursement for reasonable attorney fees, arbitration fees, court costs, and other expenses incurred. This provision encourages the parties to resolve disputes through arbitration, promoting a quicker and more cost effective resolution process compared to litigation. By including provisions for attorney's fees, it ensures that the prevailing party is fairly compensated for the expenses incurred in resolving the dispute, discouraging frivolous and unnecessary legal actions. Overall, this clause promotes fairness, efficiency, and accountability in dispute resolution, benefiting both parties involved in the agreement. Once again, I'm going to bring up the term good faith. We should never have to worry about this clause if everybody's working in good faith. So that's my speech on that. Part 16, class action suits. This section addresses class actions and representative action waivers in arbitration. Both the buyer and buyer's agent agree to resolve any dispute on an individual basis only. As a result, they waive any right for disputes to be brought, heard, decided, or arbitrated as a class and or collective action. The arbitrator will not have authority over such claims, the class action waiver. Similarly, they waive any right for disputes to be brought, heard, decided, or arbitrated as a private attorney general representative action, and the arbitrator will not have authority over such claims, representative action waiver. The representative action waiver does not apply if the buyer brings a claim in arbitration as a private attorney general solely on their behalf. If the class action waiver or representative action waiver is determined to be invalid, unenforceable, or void, class actions or representative actions must proceed in a court of law rather than arbitration. Any challenges to the enforceability or applicability of the class action waiver or representative action waiver will be determined by a court of competent jurisdiction, not by an arbitrator. This provision aims to ensure that disputes are resolved through individual arbitration rather than as part of a class or representative action, promoting efficiency and fairness in the arbitration process. I think best way to say that and sum that up is if you have a problem and you feel you need to take legal action, you're going to go to arbitration on an individual basis and not make this part of a class action suit. Um, and I just think that on an individual basis, more of the proper concerns are going to be pulled out, and then they can start seeing if there's a real problem with things as they are, so that we can all get things on the right page. Part 17, sorry. This section emphasizes the buyer's acknowledgement of receiving the consumer information statement on New Jersey real estate relationships. The buyer confirms that they have received the attached document and fully understand its contents. Remember, we started this whole presentation with talking about real estate relationships. That's what the consumer information statement is. The consumer information statement provides essential information about agency relationships and real estate transactions and their implications for the buyer. Just so you know, the consumer information statement is a document produced by, I think it's the Attorney General of New Jersey, that outlines what agency relationships are in the state of New Jersey. They feel that they have produced this document in a way that better explains agency relationships than I guess I did earlier. And they might be right. I'm not going to say they aren't. But as part of this meeting, there will be a brief presentation on agency relationships and the consumer information statement to ensure that the buyer has a clear understanding of their rights and obligations in the real estate transaction. We've already covered that. That's the first part we did in this presentation. By acknowledging receipt of the consumer information statement, the buyer demonstrates their commitment to being informed and educated about the real estate process in New Jersey. This acknowledgement serves as documentation of the buyer's awareness and understanding of the information provided in the consumer information statement, promoting transparency and clarity in the buyer agency relationship. Excuse me. I will provide anybody who asks me after seeing this video a link. Maybe if I'll even put it into the comments, um, a link to the consumer information statement so everybody knows what that is. Part 18, remedies for breach of agreement. This section outlines the provisions regarding termination and breach of the agreement. Termination. The buyer acknowledges that this agreement is a binding and exclusive contract between them and the buyer's agent for the entire stated term. Buyer's withdrawal from the agreement before the expiration date or entering into a buyer agent agreement with another brokerage during the term constitutes a material breach unless mutually terminated in writing or for legally sufficient cause. If the buyer breaches the agreement, the buyer's agent is entitled to pursue all available remedies, including recovery of the brokerage fee described in Section 5. Additionally, if the buyer's agent is in material breach of this agreement, the buyer is entitled to pursue remedies for such breach. These provisions ensure accountability and clarity regarding the consequences of termination or breach of the agreement, promoting fair and transparent dealings between the buyer and the buyer's agent. Once again, I'm going to say the words good faith. Everybody's working in good faith. We'll never have to worry about these things if everybody's working in good faith. Beware of your conversations when you're walking through a house. All right, this section warns the buyers about the potential presence of surveillance devices in properties they examine. Buyers are advised to be cautious as there may be video and or audio surveillance devices allowing remote monitoring of the property. The presence of surveillance means that discussions held on the property, including negotiation strategies, may not be confidential. Buyers should exercise discretion and refrain from discussing sensitive information while on the property to avoid any potential disadvantage in negotiations. This reminder emphasizes the importance of being mindful of privacy and confidentiality during property visits to protect the buyer's interests. Do not take photographs while you're on in somebody's houses. This section emphasizes the importance of respecting the seller's privacy rights concerning the property being offered for sale. Both the buyer and buyer's agent are reminded not to take photographs, make videos, or broadcast any interior area of the property without the written consent of the seller. Taking photographs or recording without consent can infringe on the seller's privacy and may lead to legal consequences. Buyers and their agents are encouraged to rely on the listing information provided rather than taking unauthorized visual recordings. Respecting the seller's privacy contributes to maintaining trust and fostering positive relationships during the property purchasing process. And I'm going to say that one of the reasons for this is when a home seller is putting their house on the market, we make an appointment with the home seller for a photographer to come over, and we ask the home seller to put away things that they don't want the general public to see, or we usually advise them you don't want to have that document out on the table, because if we put that on the internet, people might see that, open it up a little, try and enlarge it, and maybe they can get some information off it. That would be a strict invasion of your privacy. It's very possible that when you go to see a house, the buyer may not have, or the seller may not have thought of putting all the things away that they wouldn't want you to see. And you're going around taking photographs of it, can make them very uncomfortable. I'll give an example. Some people might have children, and if you're putting up pictures, they have pictures of the children on the wall. When we take house pictures to show online, we might ask them to take the pictures down temporarily for the photograph, and they'll put the pictures back up after the photograph is taken. We don't want these items that are considered private to be displayed to specific people that they don't want them to know, because let's face it, the seller doesn't know who you are. They don't know if you might have bad intentions of some kind of, I mean, honestly, I don't think you do, but I can't really prove that to a potential seller. So it's just a matter of being respectful. Don't take pictures. Okay. Part 21. Buyer agent may put a lien on your purchase if buyer agent is not paid. Good faith, think good faith. We're not, hopefully, never going to have to deal with this. But this section outlines the potential consequences if the buyer fails to pay the compensation owed to the buyer's agent. If the buyer's agent is not paid the agreed upon compensation at the closing or otherwise agreed in writing, the buyer's agent has the right to record a lien on the purchased property. The lien would be recorded for the amount due under the agreement, along with interest at a rate of 10% per annum and any attorney's fees and costs incurred. Recording a lien serves as a legal claim against the property, indicating that the buyer's agent has a financial interest in the property until the compensation is paid. Buyers are reminded of the importance of fulfilling their financial obligations to their agent to avoid potential legal actions and complications during the property purchase process. Once again, everybody's operating in good faith. Something happens, you're buying a property, and I can't even think of the circumstances where that would come up, but we're all working in good faith, so this wouldn't even be something that would come up. So, part 22, this is the last part. This is where your signature comes. This section emphasizes the significance of the agreement being signed by the buyer, indicating their full understanding and acceptance of its terms. The agreement constitutes the entire understanding between the buyer and their agent can only be modified through a written agreement signed by both parties. It states that no verbal representations outside of the agreement have been made, underscoring the importance of the written terms. By signing the agreement, the buyer acknowledges receiving a signed copy and agrees to abide by its terms and conditions. The note also advises seeking legal advice if the buyer does not fully comprehend any aspect of the agreement, highlighting the importance of clarity and understanding before such a legally binding document. I am going to conclude here. It was something I pretty much stated from the beginning is you want to fully understand this document before you sign it. If you are not comfortable with it, talk to an attorney friend. I hope you have one. Ask them to talk to you about it. Have them review it, tell you what they do and don't like about it. Um, I'm not going to tell you, oh, well, you have to accept this agreement just as is. If you talk to an attorney and your attorney said there are certain parts of this agreement that need to be changed, and this is how we want to change it, please discuss that with me so I understand what it is your concerns are. Because I want to work in good faith with you so that we're all together. It's super important that when you're working with an agent, you have a good understanding of them and they have a good understanding of you. So, if you do have any questions or comments or concerns about this presentation, shoot me an email to Jim, Jim, at semcelhomes.com. That's SEM as in Mary, SELHOMES.com. Jim at semcelhomes.com. You can give me a call, 609-915-2381, and I'll be glad to talk to you about the agreement. You can just give me a line number. I'll see if I can find the agreement, and we'll talk about specific line numbers. If you want to make an appointment with me to talk with me individually about signing an agreement with me, I'll be glad to do such a thing. Just let me know. I'll be glad to talk to anybody individual and be sure that your needs are being met. That is important for me to know. All right, this is Jim Semcel, Century 21, Abrams and Associates, signing off. Have a good day. Thank you, everybody. Bye-bye.